Okay, so in these unprecedented times of social isolation, we're going to be doing the remainder of the school session um, via video. Um, this may present a challenge for how we do our book report presentations, but I'll figure all that out later. This lecture is going to be split into two parts for ease of uploading. Um, we're covering chapter 12, interrogation and self-incrimination, and we'll split the chapter in half um, and do interrogation first. Self-incrimination will be the second of these two installments. The issue of confessions um, brings into focus this issue of the crime control um, model uh, versus the due process model, because um, the a confession is by some people believed to be inherently coercive. So there's attention paid to whether or not the um, confession is voluntary. Is it true? Can it be corroborated? And then, since the Miranda decision was the confession obtained in violation of Miranda, but the crime control model causes the courts um, to deal with these rights in very exacting ways. So um, let's look at how we might say that the protection against um, confessions being used uh, seemingly in a way to preserve a sense of fair play is not the concern. Is there some misconduct or disregard of the rights of the defendant by the police? Um, so let's look at the first issue of voluntariness of a confession. A voluntary confession is one that um, has happened as a free choice of the person making the confession, uh, their free will, um, not the product of overbearing or abusive tactics um, or threats or coercion. Um, the issue is whether the Fifth Amendment has been violated um, with a coercive confession. Part of your protection of that Fifth Amendment right against self-incrimination requires that the police um, not beat a confession out of you, um, and that any confession be your own choice um, to to make versus a product of some um, some illegal pressure by the police. Um, the the police can use rather crafty techniques um, that are not physically or mentally coercive, but nonetheless lead a person into making a confession, and those, of course, would not be invalid or suppressed. The concern is that a coerced confession is not reliable. It's more likely than any other to be a false confession. Um, so that's the concern with voluntariness. Um, the There's some information in the book about um, the the issue of uh, the timing of a confession. This McNabb-Mallory rule that's on page 230 is an interesting note. The police can't hold a suspect um, for an inordinate amount of time to uh, basically put a person in the position of succumbing to pressure. You can't delay the first appearance of the person or bringing them before a magistrate to be advised of their rights. So if a confession, a later decision of the Supreme Court in Corley versus United States said that any confession that is otherwise vetted for voluntariness and not in violation of a request for an attorney or a right invoking the right to remain silent, that if it's within 6 hours of arrest, there can't be a challenge for delay of bringing the person before a neutral magistrate. So the next issue is in determining voluntariness. It's often said that the waiver of rights or the test of voluntariness is also whether there was a knowing and intelligent decision to make a confession. So you look at these factors that are set out here: the intelligence of the person, their education, prior experience with the police, whether or not they have used drugs or alcohol prior to the interrogation. Obviously, that can do something to a person's ability to control their volition, their, the same thing that makes you behave more loosely and with abandon when you're drunk or high, can affect whether or not you have voluntarily confessed. And then finally, well, not finally, but this issue of emotional or mental disability. Can a person who has serious cognitive problems or mental illness give a voluntary confession? Or if someone is intellectually disabled, an IQ that is substantially below the cutoff for intellectual disability, formerly mental retardation. Those are factors that are given clear consideration. And then this issue of denying persons the physical comforts of sleep if the interrogation goes on and on, food, water, access to a restroom, those kinds of things are looked at to determine whether or not a confession was voluntary or in response to physical coercion in those cases. The next issue is the police interrogation tactics. The court looks at these factors. There are 6 of them listed here to determine voluntariness also. And as we said, there are interrogation tactics that are widely used that are not coercive in an illegal sense, but will lead a person into a confession. In fact, I've got this book. Of course, it's going to be, I assume it's going to be reversed and backward on your screen, but this person, John Reed, who's one of the authors of this book, Criminal Interrogations and Confessions, has a patented or trademarked something called the Reed technique that is taught very, very widely to police. And again, this is going to be backward, but the Reed 9 steps of interrogation, and then there's a little registered trademark symbol right here. So John Reed is deceased, but his methods of interrogation are taught to police precisely to get an unwilling person from denial to an admission or a confession. And, so long as these these techniques don't violate the law in some way, are perfectly legal. And uh, we can go over them in detail. For instance, one of them is to describe the scenario, um, you know, uh, something where serious crimes happen, but just sort of deflate the moral culpability in some way, saying things like, given the right amount of stress, that, you know, I, the interrogator, would have probably done the same thing. And you discount the seriousness of the crime in such a way that the person goes, "Oh, well, yeah. I mean, if you frame it in that way, then yes, I did that. I lost my temper and you know shook this crying baby just because I was at my wit's end. Not, I'm not a bad person. It just, given the right circumstances, like you said, you would have done it. And so, those kinds of things that get a person to confess um, are tricky, but just are not of the sort that they are unconstitutional in over weaning a person's um, sense of self determination. Um, Tricky, but not illegal. The book mentions the Frazier v. Cupp decision on page 230, and it's um, the case that says that the police can misrepresent facts to you, can lie. We got your fingerprints. We, um, someone has already said you did it. We've got an eyewitness. Your cousin ratted you out. And that not be true, but it not be coercive. That right to deceive a person is enshrined in the Supreme Court jurisprudence in Frazier v. Cupp. Um, so this case of Colorado versus Connolly highlights the requirement that there be some state action, that is, some improper police misconduct, in order to make a confession suppressible. Um, in this case, a person with mental problems comes to the police station and wants to confess to a crime. Um, and they challenge the voluntariness of that. Um, um, and the Supreme Court looked at that and said, there's no issue of police doing anything to prompt the the confession, and in the absence of state action, there's no violation of the due process clause. Um, and the the issue then becomes, well, the confession would be admissible despite, perhaps admitted mental problems, but then that would be an issue for the jury to look at and say, although this is admissible, how much weight will be given to the confession? How much do we believe it in light of uh, the person's mental problems? And there was a dissent that said that mental illness um, um, is uh, a means of involuntariness that's antithetical to the due process clause of the Constitution, um, and that a commitment to fundamental fairness would um, exclude, could lead to the exclusion of this evidence, of this confession, based on mental illness. Um, and I think it's a matter of could, um, and the court, the majority, just simply said the police didn't do anything, so there's no violation of the due process clause. Um, the book makes the clear point that that once admissibility is established, which is a decision for the judge, the defense can continue to urge the jury not to give credence to the confession, to discount it for any number of reasons: mental illness, the trickiness of the police, other um, uh, things that could affect the weight given to a confession that has nonetheless been determined to be admissible. So there is essentially two bites at the apple. If you lose your suppression hearing, the confession may come into evidence, but you can continue to or you can continue then to urge the jury, who would not have been sitting in the courtroom during the suppression hearing, um, to disbelieve the confession, the statement. You would tactically call it a statement because a confession um, sort of seeds the ground of, is it reliable, if you say, well, this is this person's confession versus a mere statement. But you can then ask the jury to discount that statement and disregard it even. Just like they can disregard the testimony of a sworn witness for any number of reasons. They can, the person was allowed to take the stand and testify, but you don't have to believe what they say. Likewise, that's true of a confession. And sometimes it's the same arguments that were made to the judge on admissibility that are then made again to the jury on the issue of the weight to be given to the evidence, or to the confession. All right, so let's look at the Miranda decision. Miranda was decided in 1966, and you are familiar with it if you watched any crime shows or whatever. It is that the decision of the Supreme Court that required that certain warnings be given to persons who are in custody if the police intend to interrogate them. And they are distinct rights: the right to remain silent, and the advice then that if you speak, that the things that you do say can be held against you, and that you have a right to the presence of an attorney. The right to remain silent, of course, grows out of the Fifth Amendment right against self-incrimination. The right to an attorney grows out of the Sixth Amendment. It's stated very explicitly in the Sixth Amendment to the Constitution. And then finally, that that if you can't afford an attorney, remember this has come after the Gideon versus Wainwright decision, that if you can't afford an attorney, one would be provided for you prior to questioning. The Miranda warnings must be given once a person is in custody, and before any interrogation can take place, no matter what the person's education or sophistication is. The Supreme Court meant for those warnings to be given in every case, and so the right to remain silent can be invoked at any time, prior to making a statement or during the making of statements. I mean, once you either in writing waive the right to remain silent, or impliedly waive your right by continuing to speak, you can still stop at any point you wish. You can assert your right to a lawyer at any point in the process. Again, I want to remind you that in a suppression situation, the defendant must move for suppression, but the state is required to establish the voluntariness. The burden is on the state to establish the voluntariness of the statement once it is challenged by a motion to suppress. The Miranda decision was a lot of times the courts had said that it was not of any constitutional proportion, but that it was merely protective or prophylactic as a means of guarding against involuntary confessions. However, ultimately, the Supreme Court said that the Miranda decision was one of constitutional significance, and its requirements, and then its further requirement that a confession obtained in violation had to be suppressed, could not be overridden by inferior courts or by statute. And there's some discussion of that history where Congress purported to overturn Miranda, if you will, by means of a federal statute. The next issue is, what does it mean to be in custody for purposes of Miranda? Because Miranda only protects you from custodial interrogations without warning. The book says you can be at the police station and not be in custody. You can be at your home and presented with a show of force, confrontation about the facts, the number of police, the degree of physical restraint, and be in custody, even though you're not at the police station. But you can be at the police station and be free to leave and that not be custodial. So there's some factors that are listed on page 233 that are worth looking at to determine that question of whether or not a person's in custody, and therefore whether Miranda is implicated by virtue of being in custody by means of being told you're in custody, or by other means that would cause the reasonable person to believe that they could not leave from the presence of the police, in which case that would be custody, whether or not someone had pronounced that you are under arrest. It's interesting to look at the fact that there's a distinct distinction made between whether you have been seized for purposes of the Fourth Amendment, such as a traffic stop, and whether that is custodial, and it may or may not be, just depending on the circumstances. You may not be in custody, but you're certainly not. You are subject to responding to a stop by the police for purposes of dealing with a traffic violation. So there has to be some seizure of the person plus some coercive atmosphere whereby the police attempt to interrogate. All right, so what is interrogation within the meaning of Miranda? First, anything that you say voluntarily that is not a response to interrogation, not a response to questioning, does not implicate Miranda. And maybe this is a good time to talk about when Miranda rights have to be given. It is not at the point of arrest. It is at the point of interrogation. They describe a situation in your textbook about, a person's arrested. And it may take time to get to the police station. You may be booked. All this stuff may go on. And you may say incriminating things. But you haven't been handed over to the detectives whose aim it is to interrogate you. And at that point, when they attempt to interrogate, when investigators, detectives are meaning to question a suspect, only then do you have to give Miranda warnings? Um, it certainly doesn't invalidate an arrest. I mean, clients always want to tell me, um, I got arrested and they didn't read me my rights. I said, well, did you say anything incriminating? Uh, and of course, if they did, it was volunteered if it wasn't in response to a question. Um, if there's no admission, no confession, then the fact that they haven't been given their Miranda warnings is immaterial. It's not to say that Miranda warnings have to be given only when a detective sits down and says, okay, we're not going to have an interrogation. If an arresting deputy starts asking questions, that is an interrogation. But until someone proposes to question a suspect, there isn't a requirement to give Miranda warnings. So that's why they have those cameras inside of cars now to catch all those statements that you make on the way to the police station that may be useful for any number of reasons, and it may be that a person just cannot keep themselves from incriminating themselves, even though they've not been asked a question. There is some discussion in this case, Rhode Island versus Ennis, where there's an interesting question about whether or not an interrogation has occurred, where a conversation going on between the police in a police car prompted this guy to say something. He's killed somebody with a shotgun, apparently, and the police are riding along and say something to the effect of, isn't it a shame that this is a school and there'll be children playing around and they might find this gun, and guess it could be dangerous. At which point the guy pops up and says, "Oh, let's go back and I'll show you where the gun is." They were given a change in the circumstances. Maybe they could have been determined to have been tricking the person into a statement, but there was something about the brevity of that exchange between the officers that the court said could not be said to be meant to evoke a response, even though I suspect that they were doing that for the effect they got. But they weren't asking him any questions. They just sort of set up the circumstance where the guy would perhaps say something, perhaps he wouldn't. So that's how that one was decided. There is also what's called the public safety exception that's talked about in New York v. Qualls. That's a situation where somebody perhaps is arrested and the police say, where's the weapon? If they, in this case of New York v. Qualls, found a holster on somebody that was empty, there's that issue of public safety. That is an exception to the Miranda requirement. If they believe that a loaded firearm is somewhere in the vicinity where a person might stumble on it and perhaps that have tragic results. There's another exception to Miranda called the booking question exception, that is simply those questions that are asked in order to to get information for the booking purposes of, like, where do you live, how old are you, how much can you read and write, etc. Those kinds of questions that are asked as a means of identifying the person, not in an investigatory setting. The public safety exception got a thorough going over during the Tsarnaev trials. The brother who was involved in the Boston Marathon bombing. One brother was killed, and the other, perhaps lesser culpable of the two, was tried. and some statements were used against him in his trial that were said to be an exception to the Miranda requirements, because they were questioning him about, is there a second bomb, these kinds of things that they were trying to elicit information to keep further injury and death from occurring. All right, so we're going to cut this one off here and resume with waiver of Miranda rights on page 236.